It's my pleasure to have with us today Luc Thevenoz from the law faculty at the University of Geneva, who's got many connections with the law school. I'm not going to detail them because he and Madeleine Morris have been collaborating on a number of projects, including the organization of our Geneva summer program. And I'm going to ask her to do the introduction.
Thank you, Chris, and my thanks to the Program on Public Law for sponsoring this brown bag lunch, which I think will be a very interesting discussion. It's really a pleasure to welcome Professor Thevenoz. He's here with Professor Foy, my co-director in the Duke Geneva Institute in Transnational Law. Many of you may have met them or will have the opportunity to do so in coming summer. Professor Thevenoz, as you know, will be speaking with us today about issues arising from the Swiss dormant bank accounts from the World War II period. Professor Thevenoz is a professor at the law faculty of the University of Geneva, where he is also the director of the Center for European Legal Studies and head of the Department for Commercial Law. He teaches law of obligations as well as law of banking and securities. He's presently on sabbatical and has had the poor judgment to spend that time at Boston University Law School. We hope to attract him here for some future period. And he is also a member of the Swiss Takeover Board, which is the authority regulating the takeover market and listed securities. And perhaps most relevantly for our subject today, he's an arbitrator of the Claims Resolution Tribunal for dormant accounts in Switzerland. So he is intimately familiar with all of the issues associated with this question and will now present us with an overview and then have a discussion with us of those questions. Thank you, Luc, for being here.
Good afternoon. Thank you for the words, for the very kind words. I'm delighted to be here with you. I'm delighted of discovering Duke, discovering this very particular place. It's wonderful, and I now understand why I was so enthusiastic when we decided to share a program 4 years ago, a program that has turned really great. I'm also grateful for having this opportunity to speak with you about a crisis that has characterized the relationship between this country and Switzerland for the past 5 years probably. I may have a too ambitious title. I titled this lecture and talk Switzerland and World War II Dormant Accounts, Lessons from a Crisis. It may be a bit early to draw lessons. Well, I was relieved when I heard on PBS two journalists talking about the elections, the primaries, and the one addressed the other one. Tom, tell me now what are the big lessons to draw from the New Hampshire 2000 primary elections? And Tom answering, you know, Bob, the elections only take place tomorrow, maybe we should wait tomorrow. So I thought we can already have a glimpse of what we can learn from this crisis. The crisis may look a bit of a word, yeah, but it's the way a lot of Swiss people thought about it, and from a neutral point of view, it was probably a significant crisis, probably the most significant crisis that occurred between the United States and Switzerland during the past 60 years. It was not only a crisis in terms of government not agreeing on something, it was also something that opposed public opinion to the country, to one of the significant Swiss industries, which is the banking industry, and also to Swiss people, because not only was discussed the dormant account aspect of it, but also the whole role of Switzerland during World War II was revisited, and revisited in a critical perspective. This started really 1993, 1994, when various international Jewish organizations asked that Swiss banks reconsider all dormant accounts that were still in the books and that had never been reclaimed or never successfully been reclaimed by victims of the Shoah or by the heirs of those victims. And new stories surfaced of people being turned down because they didn't have the proper documentation, which they couldn't have, of banks being very legalistic in their approach towards those claims of turning people down. It was not a new claim by any standard. Actually, this same claim had been expressed several times after World War II. Maybe one of the significant time in dealing with it was in 1962, when the Swiss Parliament passed a bill mandating the banks to review their accounts and to identify those accounts that were opened during or before World War II by people that the banks might deem to accounts, 1962, representing some 6 million Swiss francs. That's about $12, $13 million of today. So this probably was not a proper answer to that claim. So when that claim resurfaced in the early 1990s, it did so with much more vigor and with much more leverage than ever before, for various reasons I will shortly cover. The first one is the World Jewish Congress, the World Jewish Restitution Organization, the World Jewish Agencies, and some other organizations enlisted support from significant people in government, especially in this country. People in the Senate, people in the House of Representatives, people at the state level, the ones who license banks at the state level. So there was all of a sudden quite a significant leverage that never before had existed. Also, something which was quite new, there were class actions filed by claimants against Swiss banks in this country, claiming those dormant accounts. And this had never been done before. And this is probably a trend that then spread in other situations, but it was definitely a very strong instrument that was used, and it was clever to use it. Then the third aspect of it, I think, was that in the international media and the international public opinion, there was this revisitation of the role of Switzerland during World War II. This reconsideration of what was a neutral country during World War II and how good Switzerland had been in remaining neutral. I don't want to expand a lot on neutrality. Just a few words on that. Neutrality is a concept of the law of wars, the international law of wars. Most of the time, neutrality is elective. The country chooses not to take side in an international dispute, which means then that it must refrain from helping one side or the other, must maintain equal relationship with both sides. A lot of countries choose to remain neutral in certain situations. This country chose to remain neutral in 1914 through 1917, and went to war in 1970. Remained neutral in 1939 through 1941, and then Pearl Harbor changed that, obviously. Switzerland has peculiar neutrality status, because this is not an elective status, it's an international obligation. It's probably the only country with that kind of status. After the Napoleonic Wars, 1815, there was this Vienna Treaty, which was the peace treaty for the new Europe at the time. And at the time, Switzerland was declared permanently neutral, which meant that the Swiss committed themselves to preserve their neutrality in all further conflicts and in defending their sovereignty so as not to be used by any warring party, at the same time as other countries committed themselves to respect this neutrality. This is a very 19th century concept. It may not have been, it has changed. The way you can understand neutrality has changed, because having a neutral state in a local or regional conflict makes sense. In a world war, it's quite different, especially if that world war is perceived not simply as a dispute between countries over territory, over resources, but when it's perceived as a struggle of good against evil. And World War II was that very much. So, after World War II, you could look at neutral countries as, not maybe as virtuous, but maybe as sinful, because they did not take their share in the restoration of good, in the restoration of peace. You could say, yes, but then why did that not appear? Why did that not happen after World War II in 45, 46, 47 and onwards? Well, because World War II was followed by another war, another kind of war, Cold War. And during Cold War, the neutrality, the existence of neutral states like Switzerland or Sweden was very helpful in providing good officers to the two camps. And neutrality was still perceived as a value, as a positive value in itself. This definitely changed after 1990. This definitely changed when the second evil, first one being the Nazi, the second evil disappeared because the Berlin Wall crumbled. So it made it possible to reconsider, in retrospect, the history and position of Switzerland during World War II in new eyes, which is also part of how it was possible in the 90s for the public opinion to revisit these kinds of things. But let's get back to dormant accounts, if you will. The situation in 1995 was such that for the first time, the Swiss banks had to yield, had to take significant steps to resolve the dormant account crisis, and could not do that on their own terms. They had to do that on agreed terms with the claimants, or the organizations that represent the claimants. Shortly, there is a chronology. Shortly, in May 1996, the Swiss Banker Association came into a memorandum of understanding with those international organizations to create an independent committee of eminent persons. 3 persons designated by each side, and a chairman, Paul Volcker, who was the former chairman of the Federal Reserve Board. So a highly independent body with the task of directing, piloting, monitoring, an audit, a general audit of the banking industry during and after World War II regarding all accounts opened between 1933, that was when the Nazis took over in Germany, through 1945, and of World War II. In December 1996, the Swiss Parliament passed a bill to create another commission, but it's more of an historian commission, to revisit those same issues, but from a different perspective, also to cover other grounds, like, for example, the Swiss policy with refugees. In June 1990, and during the whole of 1996, more than half a dozen of class actions were filed in various jurisdictions, most of them, I think, in Brooklyn. June 1997, the Swiss Banking Commission, that is the regulator for banks, ordered that the banks publish a list of the dormant accounts they had identified. What are dormant accounts? Those are accounts which still have a balance, that are still open in the books, but which had been open before World War II or during World War II, and where after the 6th of May 1945 there was no news from the client. So accounts that had no news from the client for 50 years. Those were identified by a search by the banks, and 2 lists were published comprising 5,700 accounts, published by the name of the account holder, and when known, the place of residence of the account holder. Of course, at the time the account was opened. How do? You publish the list. Then you invite claims. You invite people to say, this person was somebody in my family. Or maybe this person was me, which happened. So you need to create a process to solve those claims. And this is when the Volcker Committee and the Swiss Banker Association created a foundation which instituted an international tribunal, an international arbitral tribunal, so not a jurisdiction instituted by a state or by some states, but a jurisdiction that is offered to claimants and banks. Well, actually, banks had to accept it. Claimants had the option to accept it, voluntary submission to a jurisdiction of people entrusted, according to rules, to a defined set of rules, entrusted with the task of screening those claims and then allocating the money to where it should go, including a markup for lost interest and fees levied. You could say, why did they choose to set up an international tribunal, of which I'm one of the 17 members? Why didn't they choose to go to a court, state court? There are several reasons. The first one is obvious. Where, which country, which court? Swiss courts might have a credibility problem in the eyes of the international public opinion because they seem to be close to Swiss banks. US courts might have a problem with Swiss banks. They didn't want to submit those many claims. There were 10,000 that were filed to a court somewhere. So first thing is international arbitration is a way to obviate the choice of a forum. But there are many other and maybe better reasons also. You want this process to be simple, to be fair, and to be expeditious. To be simple, you want the claimants to fill in the form, maybe add some documents when they have those documents, and not hire a lawyer, not pay fees, not having to move it forward. It must be moved forward by the tribunal itself. So you can design those rules into the arbitration rules. It must be fair. It must be fair, which means that people must have the feeling they are being heard by people who are independent from the banks. Though the banks funded the whole process, those people need to be independent. That's how they made up a tribunal made of 4 people from the US, reputed lawyers, professors, acquainted with banking and with international arbitration, 4 people from Israel, including 2 judges, 4 from Switzerland, 1 Canadian, 1 Belgian, 1 Cypriot, 1 British, 1 Brit, and the chairman is a Swiss, a reputed Swiss professor chosen among the Jewish community. So that's the setup of the tribunal. Then you want a relaxed standard of proof, because people, in most cases, at least in the cases related to Holocaust, were not in a situation to prove really. They could explain, but not deduce evidence. It's not possible to resort to witnesses. It's not possible to find huge files, mostly. So this relaxed standard of proof was written into the rules. Then the fourth thing is time is of the essence. Time is a necessary ingredient of that. That is one respect in which the tribunal and the rules that were drafted by the foundation did not prove to be the most expeditious ones, because they had a certain set of circumstances in mind, a certain idea of the number of counts, and the idea that most of the claimants would be related to victims of the Holocaust. What it turned out to be is that I've told you 10,000 claims against not 5,600 accounts, because only half of them were really claimed. The other half has not been claimed. Will be turned over to the charity, probably to those international organizations. So that means that for every account there is, on average, there are 4 claimants. And how do you decide between 4 claimants? It's a lengthy process, because you have to hear them, you have to weigh their arguments. Each of the 4 claimants may be in the same family, and they may be cousins who don't know that each other still exists. I've seen that. I've seen brothers and sisters not knowing about each other. But they can be also claimants belonging to several families, but with somebody in their tree with the same name, surname, and place of residence. Some names were very common. Some place had a lot of people with the same names. And so you have 3 claims which may be evenly plausible, or which may be not evenly plausible. It's a lengthy process. So this process turned out to be fair, but not that expeditious. Currently, it's a process in 2 steps. There is a first screening, and then there is an arbitration stage. We've almost completed the first screening. I think that we have 200 claims which are still being handled, but that means a little bit less than 10,000 claims have been cleared in the screening, a lot of them being actually denied in this first screening process. Then there's the arbitration stage, and in this arbitration stage, our last figure, I think by the end of January, was that we had resolved 2,043 claims by an award, which is a significant number, but I think there's about almost the same number still to come. The second problem that we've encountered in applying those rules is a problem about documentation. At the arbitration stage, the claimants get to see all the documents that are in the bank files, obviously, and they can comment on that. The problem is that those documents are not sometimes very helpful. In most cases, what you have is one, maybe two or three, but quite often one document at the time when the account was opened. One document where you see a name, first name, place of residence, maybe a specific address. Maybe you see some relatives who are mentioned, a signature. Okay, that helps finding out who is the right person, who was this account holder. Not much, but it helps. But then you don't have accounts for the whole story, because under accounting rules, all companies, bank included, have to retain their accounts for 10 years. But then they can dispose of them. If they haven't disposed, they have to produce them. But if they've destroyed it, which occurs, those accounts are not available. And you have a lot of claimants who see that, well, that's their grandfather here on the form, and there is currently a balance of 4 francs and 70 cents, that may be $3, and they say, I can't believe that my grandfather opened that account for this amount. It's true. It most certainly did not happen. How did it go to this balance? We don't know. Sometimes we know. Sometimes we don't know. Quite often we don't know. It may be that the amount was repaid when somebody came and collected it. And then some interest was credited. And these 370 or 470 is the interest that was credited at the time, that was not paid out, that was just credited. You know, a remaining small balance. Maybe that this small balance exists before because a lot of fees were levied and charged to the account. And maybe those fees were excessive. Maybe sometimes you have an idea of quite high fees, steep fees, which are unacceptable. So people think it's unfair. We don't know. We can't know. And the tribunal is not helpful. Actually, the tribunal is not helpful. It doesn't have the information because the bank may not have this information. We are in a situation, and this is a situation known to historians, but not usually in litigation, that you will never get to the whole truth. You will get to know part of the story, but not the whole story, which is very frustrating. So this process might need improvement if it is to be repeated. We'll come to that in a second, because the second aspect of it I want to discuss is the Volcker Committee report. Just before that, remember August 1998, in the framework of those class actions pending in Brooklyn, a global settlement was reached between the two largest banks, Credit Suisse and UBS, and the international Jewish organizations that I mentioned. Class actions for 5 classes of claimants. First class is dormant account, people who have a claim against dormant accounts. But 4 other classes do not relate to that. 2 classes relate to slave labor, 1 to looted assets, 1 to, I'm forgetting the 5th one. A global settlement of $1.25 billion, payable from 1998 through 2001. This amount will be paid by those 2 large banks. Against this settlement, there is a general release, not only of those 2 banks, but of all banks, and of the Swiss authorities, and even of the arbitrators who worked to try to find the right claimants. So we have this settlement. It's important to know that all amount that will have been paid to claimants under the rules are credited against the settlement, because of course it's part of the first class. So all amounts that this tribunal has already allocated, currently it's more than 26 million, not including the multiplier for the interest loss, all these amounts are credited against this $1.25 billion. If you will, the first class has a first claim, and then other classes have a residual interest in the $1.25 billion. This is important to know what will happen later on. In the meantime, ICEP, the ICEP committee chaired by Paul Volcker, has monitored these huge audits on the banking industry. It's huge. I think nothing of the like has ever been entertained anywhere. I mean, the whole industry in one country undergoing an audit of every single document that is available. They had estimated that between this period, 33 to 45, there were 6.8 million accounts that were either open or opened. All sorts of accounts, domestic and international, of course. Out of this 6.8, they found documentation for 4.1 million accounts. It's a very significant numbers. If you think that archives can be destroyed legally, it's maybe because of the very conservative nature of the Swiss bankers. It has a lot of disadvantages, sometimes advantages. They could trace about 2/3 of those accounts, which is rather good. So they could really browse every single document relating to those, still available, relating to those 4.1 million accounts. And in December last year, 2 months ago, almost 3 months ago, they came up with a report, the report on dormant accounts of victims of Nazi persecution in Swiss banks, published by ICEP. There is a lot of interesting things here, and I can't summarize that. There are 2 major conclusions that I want to draw out of it, and for the first one, I will take Paul Volcker's words when he appeared before the Committee on Banking and Financial Services of the US House of Representatives on February 9 last month. The first one has to deal with the general suspicion that the banks had been defective, to say the least, sometimes mischievous or even fraudulent in their refusal to pay accounts. Volcker said, intensive investigation by our auditors did not find general evidence of systematic destruction of records of victim accounts, organized discrimination against their accounts, or concerted efforts to divert the funds of victims to improper purposes. Nevertheless, we did find confirmed evidence in individual banks of questionable and deceitful actions in the handling of the accounts of victims, including withholding of information from Holocaust victims or their heirs, inappropriate closing of accounts, failure to keep adequate records, many cases of insensitivity to efforts of victims or heirs, and a general lack of diligence and sometimes even active resistance in response to earlier private and official inquiries about dormant accounts. No general conspiracy, but a widespread pattern of insensitivity and reluctance to deal with that problem, which actually we knew that's how it took so long to get to really try to solve it. Now, the second part was also to see how many other accounts should be identified, and maybe accounts that were closed, but that nevertheless should be repaid to the heirs of the ones who had deposited money. They employed a very sophisticated technology in terms of analyzing accounts, also matching account names against known lists of victims of the Holocaust, Yad Vashem, or there are several such lists with about 5.5 million names. And out of that, they drew a general conclusion that they could estimate, that they could pinpoint about 54,000 accounts that are probably or possibly related to victims of Nazi persecution. And out of those 54,000 accounts, they identify 25,000 that should be published for claims to be filed. In those 25,000, very shortly, you find accounts that were still dormant and that had not been identified in 1997. Of course, in the meantime, the criteria were a bit wider, and also the means to identify them were much more intensive. Accounts that were closed and paid out to people who had plundered them, like Nazi. You know that there were extortion. The Nazi authorities sometimes said, okay, you can leave the country, you sign here so that we can get your money. And I think they found around 1,000 such accounts that they could identify as having been paid out to Nazi authorities or people. There are accounts that were closed improperly to profits for the banks. Well, under the wrong assumption that they could close them, which was wrong. And there are a good 10,000 accounts that were closed and that we don't know to whom it was paid out. And when it is related to people who might be related to Holocaust, then the suggestion, it's not a decision, is to publish them. The question being, who bears the risk of not identifying who got the money? If it's the bank, then the bank incurs the risk of paying twice, of paying anew the same amount. The decision is not with the ICEP. The decision is with the regulator, and the regulators will have to make a harsh decision because there are two problems. The first one is with those closed accounts, how you treat them. It's not obvious. I mean, if you do apply law strictly, probably you should not publish them. But if you look at it from a more distant perspective, and if you look at it from the whole context, you may want to publish them. We don't know what they will do. And the second problem about what to publish, there will be a third list, we don't know what it will be, is that now we sort of two groups of banks. The two large banks, they know they will still have to deal with that, and anyway, any money that is paid out, if it's not paid to individual claimants, it will pay it out in the New York settlement. So they have no financial incentive not to get into that, provided that it is, in terms of, it is expeditious, not too costly in the administration. All other banks have a general feeling that first they're much less concerned in terms of number of accounts, and they've had it, and they feel that it should be kept to a minimum. It's a feeling it's difficult to understand from outside. Maybe what their perception is that they've paid already dearly for that. The audit have cost around $500 million, just the audit. Not yet. And then there are, of course, the money that is being repaid, but that is not against the banks because it's money for the clients anyway. There was a significant, they got a terrible hit. So they are more reluctant than the large banks to be generous in this third publication. Now, third publication means you still need a claims resolution process. How do you do it? It seems that the services of the tribunal will be enlisted again. Definitely, it will be with different rules, because now that we do have some experience, we need to streamline that, to make sure that it doesn't take 5 more years or 10 more years to deal with 25,000 account or 10,000, 15, I don't know how many that will be, but anyway, that will be a very large number, and we need a way to deal with that efficiently. Lessons. Are there lessons to take? So many. Are we taking them? Oh, it's difficult. It's another question. I have at least 3 suggestions. There are so many others I don't have time to dwell into. First one is arbitration can be an option for mass litigation if you want to go beyond lump sum compensation. Lump sum compensation, Toshiba had defective floppy disks. So they tell you that if you bought a Toshiba computer before such date, you're entitled to a $1,000 rebate against your next purchase. And if you bought it afterwards, you're entitled to a $400 credit against your next purchase. But that is lump sum. If you want to be individual, if you want to take account of specific circumstances and of discrete circumstances, and if you want also to modulate the amount, arbitration is a solution, a possible solution, but it needs very careful drafting at the rule stage. It needs capitalizing on the experience that has already been gained, not only, of course, with this tribunal, but in the UNO with the claims against Iraq, in Sarajevo, in the gains against real estate, and so on. Second lesson, it's a matter of it's at the political level. Political isolation of Switzerland is not an option anymore. I think one of the reasons Switzerland was first to take the hit, while you've seen that in the meantime other industries and other countries are being also are being asked to give back things that were taken out during the Holocaust. One of the reasons why Switzerland came first, there are many reasons. Among them, arrogant bankers, definitely. They are arrogant anywhere, but Swiss are good at that. But it's political isolation. Switzerland is a tiny country, doesn't have a significant international role. It had a larger role when neutrality did count. It has a much less significant role now that good offices are not very important anymore. It's not a member of the European community. It's not a member of the UNO. It's some, you could say it might be a self-designed outcast of the international community. I think what we have to learn is it's not possible anymore. Being neutral in a world that existed in the 19th century, early 20s, is something different than being neutral in a world where other kind of disputes can arise, not the kinds that we experienced before. The third lesson is that a legalistic approach to any problem is no replacement for a moral re-examination of any course of action, past or present. And that is one of the big mistakes that the Swiss bankers, the Swiss government, sometimes the Swiss people at large make, is to answer from a legal point of view to a claim that has other grounds. And you cannot escape a moral re-examination of past things and accept that mistakes were made and try to make good them as far as it is possible. Thank you for your attention. I'd be glad to take questions and take debate.
On your second lesson, I'm wondering what the public opinion is in Switzerland on neutrality.
Oh. Well, it's difficult to say about neutrality because currently the issue is how near do we get to the European Union? And I'm afraid that second lesson is not being taken because we're a small country and the idea of being too close to the European Union or being a member is linked with the fear that we'll be overwhelmed, that the ways we deal in particular with democracy will not be possible if a member or if tightly linked with the European Union. Switzerland has just completed 7 bilateral treaties with the European Union in specific areas: education, transportation, immigration policy, and 4 other areas. And those treaties, unlike other countries, will have to be voted by the people at large, and this will happen in May. That's correct, that's in May. This is not becoming a member. This is not abiding by some other jurisdiction. It's just the treaty, you decide what the rules will apply for, and they can be resigned, they can be terminated. Yet, what is happening, what has just been happening between European Union and its Austrian member has frightened off some Swiss. And it may turn out that on the 21st of May, the answer may be no, which for me would be a catastrophe, an absolute catastrophe. That would mean we want to be an Indian reservation. I don't think it's an option that we can pursue, but a lot of people tend to think that way. So I don't know where we stand, and I'm very anxious to know what will be the answer of the people on the 21st of May.
On your first round of claims for the 78 or 7,900 dormant accounts,
5,600.
It sounded to me as though you might be allowing double recoveries in some cases.
Correct.
So that when you have more than one claimant and you can't choose among them, the judgment is not to parcel out the account, or is it to allow double recovery?
To the extent possible, we try to avoid double recovery. But if there is no way to depart between several claimants, we may suggest an agreement between all of them to share, or order double payment. there are no set criteria. It's very much a matter of individual circumstances. What I've learned in the process is that there are so many individual cases, and the information is quite often very sparse. What you have to know also is that among those 10,000 claims that we've been processing, it seems that only about a fifth of them, about 20% of them, are Holocaust related. Those are the tough ones, of course. But 80% of those claims are simply by families of people who had money and forgot about it, or didn't tell, died without telling. And there are people who are totally crazy about confidentiality, or they have a problem with their tax authorities. So many reasons not to tell your family. And that means of those accounts that we have been examining, those against which there are claims, which is about half of those 5,700, I think a good majority of them are not Holocaust related. Probably also we deal differently with those where we can ask for information. Families that were not affected by Holocaust can provide a lot of records that people who had to move or people who were killed cannot provide. Yes, sir.
Weren't there a number of secret accounts, and how are these being dealt with?
Okay. There is a large misinformation on secret accounts. Numbered accounts, right? Swiss numbered accounts are considered as a synonym of secret account. What I've seen from all the files I've had, which is now several hundred, is that an identity has always been known to the bank. It may not have been the right identity. At the time, they didn't have the money laundering worries. So they didn't necessarily ask for a passport or for an ID to check that this person who said, I am Herbert Smith, is actually Herbert Smith. But there is always one person, at least, quite often several persons, known to the bank. What was missing usually, well, usually they would have a town and a country, and in most cases, but not always, an address, a full address. But a full address, people move, so it may not be very helpful. In most cases, they wouldn't know more. They wouldn't know date of birth. They wouldn't know other personal data. But numbered account were never a measure for the banks not to know who opened an account. They were a measure to limiting the number of bank officers who knew the identity of the person. So if you have a numbered account, you identify yourself by a code or by a number. That means that the teller that you meet or the person that you meet don't know who you are. There are only 2 or 3 persons who know that. But there were in all the cases I've seen, there were always those identities. And of course, it was a tough decision to decide that they would publish the names of the account holders, because there's always this idea of secrecy. We've promised confidentiality. How can we break that? And under Swiss law, it wouldn't be possible except for a generous interpretation of the provision, saying, in this interpretation that was done by the regulator says so, in that circumstance, the interest of the account holder, the presumed interest of those account holders on accounts that were not managed for 50 years, that they had no contact with the banks for 50 years, presumed interest is not confidentiality, is finding who has a right to that money. So we will break confidentiality in favor of opening. But actually I had one injurious phone call with people in France, those 80%, right, of people who forget and so on, saying, we are terribly embarrassed. How did you dare? I didn't do anything. How did you dare publish our names? Now everybody in the village look at us. Of course, they suspicious that there is a huge amount of money. Actually, if you look at the actual amounts, there are substantial amounts. In a few limited cases, up to 1 million Swiss francs. But in a lot of cases, there were amounts under 100 Swiss francs. So there were a lot of suspicion. But those cases are marginal. I mean, clearly the publication was clearly warranted. It was the thing to do. Please.
I'm trying to understand the feeling of the bankers, of the smaller banks. So, is this correct, that from their point of view, they're doing their jobs, they are tending to their accounts, they have no obligation to start sorting through and sifting through their accounts in order to figure out which ones are dormant. They're not stealing anybody's money, and they're just tending their accounts. If somebody comes with the information, they give them the money. They're doing their job. Now they've been imposed upon and caused to spend $500 million in doing a sorting and auditing job that's not. They have no real obligation to do it, and on top of that, everybody's angry at them. Is this their perception? I mean, what is the sort of their side of the story?
Right. Oh, it's difficult to tell their side of the story, especially because for the past semester I've been living here in the States, so I'm a bit far away from them.
Plus, it's dangerous to tell their side of the story.
Well, but anyway, they with the tribunal, some of them are very cooperative, some are not very cooperative, but still they have to work with. But I can't say they're friendly. I mean, I don't have very good relationship with them. I don't have a bad relationship, but it's a difficult situation. What I think you've clearly summarized their general feeling. Well, maybe we had to do, or at least we were made to do something which cost us a terrible image loss, plus terrible financial burden, plus a terrible work. I mean, they've spent a number of new employees, or a lot of things, a lot of people were caught at doing that, which they needed to do. That's true. But they think that now that they've gone through that, they would like the problem to be solved, especially because there is that settlement in New York. So that should take care of it. Which probably does not take care of it, but that's the way they feel. Now, what you said is also interesting, because you have to understand, it's interesting, it's the way the Swiss banks at large understood their role before the crisis. Their idea is, we have accounts, but it's not our mission to actively trace people. And usually our foreign customers don't want us to trace them, because when we do that, we may trigger inquiries, investigations, and so on. So really, they have to come to us. We'll keep the money out as long as it takes. There are no escheat laws in Switzerland. There is no limitation. This is a point that was settled at law in the late 50s. There is no statute of limitation applying to an open and dormant account. This is a permanent liability forever and ever, which is plainly wrong. I mean, it should change. We will have soon, I think, some sort of escheat law, because it can't work. But the banks were confident that would work. Actually, it didn't turn out that it didn't work. They were really blind about that problem. Though they were told that it was wrong, they kept doing that. So their idea was, they have to come. If they come, we come forward. But they, of course, since we still have this requirement of secrecy because our customers are so sensitive about it, we want to make sure first that the persons who inquire are the right persons. We don't want to answer to somebody who is not entitled to that money. So please come forward with the evidence. And that's one of the basic problems with the Holocaust-related accounts. They asked for things that could not be provided. And they did not, at any time before 1995, realize that they had to deal differently with those accounts than with the typical, average, plain vanilla account. Please.
If you, in the class action, if the process of claims for the 5 classes runs through all the claims and there's still funds left over in the 1.525 billion, who has the residual claim, if there's anything left?
Okay, so the 4 other classes are eligible. It's very difficult to make out who can claim how much. So the settlement, which is still provisional, has not been yet approved finally by Judge Dormant. This settlement provides for a special master who's been appointed a year ago to work with the claimants' representative, with the plaintiffs' representatives, to work out a payment plan and rules. I'm sure a lot of has already been done. Nothing is final, and I'm not familiar with what they've come up with. And I know that one of Judge Coleman's concern is that dormant accounts should not reap the whole sum. There should be money left for the others, which is a problem for the multiplier. There's something I just touched upon without telling you about it. What we're currently doing is allocating the principal, the balance that is here. But for all Holocaust-related accounts, which is not always easy to assess, there will be a multiplier based on the idea that interest was not payable. In most of those cases, they were current accounts not bearing interest. And fees were levied. And considering the whole set of circumstances, retroactively, money should be paid for interest and fees should be restituted. So the general rule is the balance will be multiplied by 10. That means that currently we have allocated 26 million. Ultimately, we know that the first accounts that we have run for about 70 million Swiss francs. That means that the total payout should be somewhere in the 700 million Swiss francs range, which is less than half, the 1.25. But of course, then we have a third list, and the third list may not be for very significant amount for each account, but it might still run in high figures. Of course, if it turns out that all published accounts run for more than $125 billion, the additional money will be paid. It's not 125 is not a cap on dormant accounts. It's a cap on the settlement. Okay.
If a bank employee had wanted to impersonate a Holocaust victim he or she had known before in order to empty an account, was that possible?
I guess that kind of fraud is always possible, as we know in ordinary course of business. To what extent it did exist? This is something that the Volcker report does not speak much about, probably because it's very difficult to assess the real extent of that. They were more concerned actually about Swiss fiduciaries, attorneys, notaries, or other people acting in a fiduciary capacity than with bank employees. And about fiduciaries, I don't have clear in mind everything that they've said, but what they've said is that they couldn't really come up with very substantial information. And they hope that the other historian committee, which investigates not only the banks, but actually the other professions, will come up with some more information. But I'm afraid this is one of those situations where, post factum, it's very difficult to know when an account was improperly closed. They've singled out a few of them, but it's not a significant number. Whether there are other, they certainly must have been other, but they didn't have the evidence to find them.
And you can do that, or the banks can do that, entirely because they've kept records for 50 years?
Well, because they've kept records for the very first documents, and then maybe for 50 years, or sometimes for less. Sometimes they've kept records of at the time of closing the account. These are kind of records I haven't seen because currently the accounts we have are all dormant. None has been closed before, but sometimes I guess they have records of the time it was closed. And with those kind of records, they could ascertain whether they knew to whom it was paid. It was paid to unknown. They are numbered in the 25,000 that I've mentioned. And if they're paid to somebody identified as linked with the Nazi regime, they have singled out some of them.
Why did they keep this one document?
If they're cautious, which is not mandated by law, probably just to show to somebody who will come with a formal statement and say, but there is money in your bank. Look, there is a statement dated 1946. Yes, but look, here in 48 we've paid out. So that might be the reason why they kept it. But they have to keep those kind of documents for 10 years. This is law. Beyond that, I'm not sure that... Probably they kept it also because they had enough room to store. And when they didn't have enough room, that were all archives that were destroyed. Which is a pity, but we know that kind of things happen in all sorts of industries because they didn't think that there was a risk there. Didn't feel that there was a risk.
If there are no further questions then, thank Professor Thevenoz.
Thank you very much.